In 1833, the case Barron v. Mayor and City Council of Baltimore was decided by the Supreme Court. Writing the opinion was Chief Justice Marshall, who said, "The Constitution was ordained and established by the people of the United States for themselves, for their own government, and not for the government of the individual states. Each state established a constitution for itself, and in that constitution provided such limitations and restrictions on the powers of its particular government as its judgment dictated. The people of the United States framed such a government for the United States as they supposed best adapted to their situation and best calculated to promote their interests. The powers they conferred on this government were to be exercised by itself, and the limitations on power, if expressed in general terms, are naturally, and we think necessarily, applicable to the government created by the instrument. They are limitations of power granted in the instrument itself, not in distinct governments framed by different persons and for different purposes. In the mind of the court, since the Constitution established the government of the United States and not the governments of the several states, then any general statement it contained logically applied only to what we now call the federal government. Needless to say, that was not the position of the opposition. The counsel for the plaintiff, in error, insists that the Constitution was intended to secure the people of the several states against the undue exercise of power by their respective state governments, as well as against that which might be attempted by their general government. Yet in support of this argument, he relies on the inhibitions contained in the 10th section of the first article. We think that section affords a strong, if not conclusive, argument in support of the opinion already indicated by the court. According to the court, the fact that each clause in Article 1, Section 10 specifically states that no state shall is proof that the court is correct in its opinion. The preceding section contains restrictions which are obviously intended for the exclusive purpose of restraining the exercise of power by the departments of the general government. Some of them use language applicable only to Congress. Others are expressed in general terms. The third clause, for example, declares that no bill of attainder or ex post facto law shall be passed. No language can be more general, yet the demonstration is complete that applies solely to the government of the United States. In addition to the general arguments furnished by the instrument itself, some of which have already been suggested, the succeeding section, the avowed purpose of which is to restrain state legislation, contains in term the very prohibition. It declares that no state shall pass any bill of attainder or ex post facto law. This provision, then, of the 9th section, however comprehensive its language, contains no restriction on state legislation. Isn't it amazing that the court used terms like obviously intended and the demonstration is complete to demonstrate that their position is correct? Yet not a single clause they quote, nor any other in the Constitution, actually states or infers that its purpose was solely for the central government unless otherwise stated. Which brings us to the Bill of Rights. If these propositions be correct, the Fifth Amendment must be understood as restraining the power of the general government, not as applicable to the states. I would say there's a very, very big if, especially when you consider more than just the cherry-picked clauses the court has used. Let's start with the preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Why did we, the people, ordain and establish this Constitution for the United States of America? Not, as the court stated, for their own government, but for a more perfect union. A union of what? A union of states.